can say, I have already informed you and this is what it is. So the court will dismiss the case as being frivolous or vexatious, right? That's what it is. So in that case, what power does the court have? It can strike out the pleadings. We already read where when there is a fictitious address or whatever, the defense can be struck out, right? And there shall be a stay of the suit, right? But if we are doing the pleadings for all these unnecessary or vexatious or frivolous, we will take up the latest example. I have no idea about the details of the case, but there was news that Juhi Chawla, she's a actress, okay? Juhi Chawla had filed a case in the Bombay High Court about 5G connection, okay? And when the court just read over it, they found it to be frivolous and therefore it was dismissed as being frivolous, okay? So that's what we mean by striking out pleadings, which may be unnecessary, scandalous, frivolous or vexatious, or which may tend to prejudice, embarrass or delay the fair trial of the suit. So even if there is because of such a suit, if there is a delay in the trial, then even in such cases the pleadings can be struck out. For example, there is an interim order, okay? I go and file an appeal in the High Court or the higher court saying that this particular interim order is not right, okay? And when the case is gone through by the court, then the court feels that it's a very frivolous reason on which I have come against the interim order. Then the court can strike out the pleadings. Clear? C, which is otherwise an abuse of the process of the court. So time pass, But if we put it in a very colloquial this thing, then it is time pass. Okay? Some people have the habit. They have a lot of money or they have that fancy for going to court and all those things. There are few people like that, very rare. So it is only just like that they want to file a case and be there in the court and all that. So in such a cases, it is an abuse of the process where there is no real reason for filing the suit. Frivolous, right? When there is no real reason for filing the suit, they have filed a suit. So in that case, it becomes an abuse of the court. Okay? Then we go to Rule 17, Amendment of Pleadings. The court may at any stage of the proceedings, we have already read, right? There should be an application by either party to the court for amendment of pleadings, and once the court allows, then the pleadings can be amended, right? Okay. The court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner and on such terms which may be just. Why do you call it just? Because if I have forgotten some point, okay, and all of a sudden I remember, oh my goodness, I forgot this. Let me include it in the pleadings. So can I just file an application and tell the court, I forgot to write this, please allow me to amend? I cannot do that, right? So the court also will not allow, first of all, right? So there it should be just. Just means what? In order to get a fair trial, in order to get justice, okay? So then it should be done. As an afterthought, if I start writing something, that's not going to work out. And all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. What do you mean by commencement of trial? Commencement of trial refers to the starting of the proceeding, the evidence stage, right? Plaint has been given, the written statement has been given, everything has been given, okay? The proceedings is about to start, the trial is about to start, and then I say, oh my goodness. So once the trial starts, I cannot make any amendment of pleadings unless I show it as absolutely necessary. For example, if I am going to file a case for change in the address, okay, then I have to prove to the court that the defendant address, what I have already given, is not correct. Not correct in the sense I didn't give it wantonly, but the person has changed it after receiving the summons. Something like that, I have to convince the court and then I can change the address. Okay. Then rule 18, failure to amend after order. See, once they have given an application and the court has given an order granting the permission to amend the pleadings. Okay, so rule 18 deals with that. Failure to amend after order. If a party who has obtained an order for leave to amend does not amend accordingly within the time limit for the purpose by the order, or if no time is thereby limited, then within 14 days from the date of order. Either the court may say you have to amend the pleadings within so and so date. Okay, date in the sense, say probably for a period of 30 days or 12 days or maybe 10 days or 1 week or whatever it is. But if no time period is given, then it shall be done within 14 days from the date of order. He shall not be permitted to amend after the expiration of such limited time as aforesaid, or of such 14 days as the case may be. If he doesn't amend it within the time period granted by the court, or within the time period of 14 days from the date of order, in that case the plaintiff pleadings cannot be amended at all. Okay, with this we complete order 6. I'll meet you in the next session. Thank you.